Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. Okay, today I will continue my explanation about the Chinese Maritime Police Law. In the first video, I have explained the statement on March 4th, 2021 by Ting Huilin and on February 11, 2021 by Takashi Saito. And in the second video, I have explained on February 16, 2021 by Sokuli and at the same date by Jalan Chong and then in the same date too by Hong Tao. And now I will explain the statement on February 16, 2021 by Nguyen Hong Tao and associate and now I will continue my explanation by Hong Tao. Okay. First, the law legalized the illegal action by the China Coast Guard, shooting, ramming, and sinking fishing boats from other countries that conduct normal activities in their own exclusive economic zone under UNCLOS. The annual fishing ban imposed by China since 1998 that is largely enforced by the Coast Guard will challenge the regional fishing community. And then the second, by allowing the China Coast Guard to demolish other countries' structures on islands under Chinese jurisdiction. The law breaks the self-restraint principle agreed to in the Declaration on the Conduct of Parties in the South China Sea and changes the status quo in the Spratly Islands. And then the third, the law legalizes natural resource exploration and exploitation activities conducted by Chinese companies on the continental shelves of other countries. And fourth, the law allows the China Coast Guard to prevent any illegal freedom of navigation and overflight operation, including by the United States and its allies in the East and South China Seas. To open fire in disputed waters would violate the prohibition of the use of force or any form of threat in relation between nations as stipulated in Article 2 of the UN Charter. The law also aims to justify China's rejection of the 2016 arbitration decision in its dispute with the Philippines. More fundamentally, the new law could shake the international rules-based order. Under the law, the China Coast Guard is not a maritime law enforcement agency, but rather a military force under direct command of the Central Military Commission. Any use of force by state agencies in other countries' waters that China claims as its own can be qualified as an act of war. Other countries would then respond based on the right of self-defense, leading to instability in the region. Ultimately, this will reduce trust among parties and cause the failure of the negotiation on a code of conduct in the South China Sea. Nguyen Hong Tao is an associate professor in the Law Diplomatic Academy of Vietnam and National University of Hanoi. And then the next, in the same date, February 16, 2021, by Nong Hong, Executive Director of the Institute for China-America Studies, provide this statement. China's Maritime Police Law, which entered into force on February 1, 2021, represents an integral step toward clarifying and standardizing the operation of the China Coast Guard. Following a long process of promulgating relevant laws and regulations, since its formation in 2013, the law for the first time explicitly specifies the circumstances under which the Coast Guard will be allowed to use weapons on foreign vessels. Strict regulations in the law stipulate what kind of weapons may be used, while the Chinese and US Coast Guard are the only two that possess vessels large enough to carry anti-ship missiles. Currently, only China Coast Guard vessels are equipped with water cannons and some self-defense weapons. The purpose of the use of force by the Coast Guard is to take measures against ships suspected of serious violation of laws and disobedience of orders. This interpretation follows the principle of minimum use of force and is not conceived to encourage the use of force in combat. It is a common practice for coastal states to authorize maritime law enforcement personnel to use force on foreign vessels. For other example, from East Asia, see Japan's revised Coast Guard law in 2001. South Korea's relevant announcement in 2016 and Vietnam's new Coast Guard law in 2018. Similar practices by China invite skepticism due to the growing disparity in maritime capability between China and the coastal states with which it is embroiled in ongoing maritime dispute. To ease this anxiety, China should demonstrate greater political will to engage with regional maritime law enforcement agencies to minimize the risk of incident at sea. It should also take the initiative to institutionalize joint training and exercises with other claimant state Coast Guard forces. Finally, China should work to further bring its maritime law enforcement operation in line with international practice, for example, by taking necessary measures to restrain unauthorized, impulsive behavior and the abuse of force by local personnel. Na Hong is Executive Director of the Institute for China-America Studies. Dr. Hong is also a research fellow at the National Institute for South China Sea Studies in China and at the China Institute of the University of Alberta in Canada. And then the next is on February 19, 2021 by Sumanti Permal, head of the Centre for the Strait of Malacca with the Maritime Institute of Malaysia, provide this view. On January 22, 2021, the National People's Congress passed a new law that provides the China Coast Guard with all necessary means to stop or prevent trade from foreign vessels and specifies the circumstances under which different weapons can be used. According to media report, the law also allows the Coast Guard to destroy structure built by other claimants, implying that China will safeguard its national sovereignty, security, and maritime rights in disputed areas of the South China Sea. Under normal circumstances, this could be a sign of generic progress that the China Coast Guard laws are coming more in line with the practices of other Coast Guard around the world. But this new law stipulates powers and duties in jurisdictional waters that include highly contested areas in the South China Sea. As such, it is seen as brinksmanship and signal a threat to the law enforcement of other countries operating in the same vicinity. By virtue of China's 9 dash line claims, the law applies to the entire South China Sea, which challenges the assertion of other claimant states including Brunei, Malaysia, the Philippines, Vietnam, and Taiwan. Coast Guard are not military forces. Instead, they are law enforcement forces that primarily perform constabulary roles and are usually armed with machine guns or at most medium caliber deck guns. Although the Coast Guard of some countries such as the United States, Japan, and Malaysia carry small arms aboard their vessels for law enforcement and self-defense, this hasn't been as controversial as the China Coast Guard practices, which might not follow international standard. The provision in the new law allowing the use of weapons against foreign ships in disputed waters near Chinese claimed features concern all claimant countries. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe to the channel. See you next video, and bye bye.